straight away take lordships to the grounds on which the petition satisfied.
Yes, sir.
Number one, the preliminary notification which was issued. Yeah. It is, my lords, 15/3/2024, page 170.
15/3.
2024, page 178, issued under section 28, subsection 1. Now, Lord, lordships may only kindly note for
Yes, sir.
please,
Ready, sir.
page, my lords, 178.
Page 178.
Yes. But 178,
Yes.
they say the acquisition is for the purpose, general as vague as possible. They say it is for industrial purposes. That's all they say. They do not specify the grounds, the purpose of acquisition. Now, my lords, thereafter, my lords, notice is issued.
15/3/24 is the 28
The
one.
preliminary notification.
That is 28 one.
Oh, the 21. Now, my lord, thereafter, the
28/4 ಆಗಿದೆಯಾ?
ಮಾಡಿದ್ದಾರೆ.
Yes.
Lord, the special land acquisition officer, my lords,
Hmm.
on 6/5/2024, under section 28, subsection 3, issues notice inviting, my lords, affected persons to file their objections within 30 days. Lordships may kindly note this one. 6/5/2024.
6/5.
2024, giving us time to file our objections on or before 6/6/2024 under 28 subsection 3.
6/6/2024.
But not very strangely, he fixes a date for conducting an inquiry on 22/5/2024.
22, even before the.
And before that, he does not. That is one of the infirmity which has been pointed. Petitioners, my lords, have filed detailed statement of objections before the authority.
Hmm.
2 sets of objections are filed, but essentially contending, well, I'll straight away take lordships, what is the objection filed? If required, we state, it is our case, that the lands have been converted for non-agricultural purposes. We have developed a residential layout. Planning authority has granted us the plan approval. We have entered into agreement of sale for purpose, prospective buyers, etc. And in the new definition of industrial purposes includes townships. Therefore, you please consider dropping of acquisition proceedings is our objections filed before the SLAO. SLAO does not consider anything in a cyclo-styled order, my lords, recommends to the government to go ahead with the notification, and the government, my lord, issues final notification on, my lords, 22/12/2024. Yes, 2/12/2024. But this lordships will get it at page 29. Now, this is what is called into question. 5 grounds have been urged before your lordship.
Grounds have.
Yes, number 1, on the ground of procedural fairness and violation of principles of natural justice. Now, but as I pointed out to lordships, the section 28 subsection 3 of the act contemplates a 2-fold inquiry. May I straight away take lordships to that provision?
Good evening. KDB Act.
If lords have to see 28 subsection 3.
Yes.
28 subsection 2. On publication of a notification under subsection 1, that is preliminary notification, the state government shall serve notice upon the owner or where the owner is not the occupier, on the occupier of the land and on all such persons known or believed to be interested therein, to show cause within 30 days from the date of service of the notice why the land should not be acquired. This is the first step, issuing notice for 30 days, which in this case was granted.
So 30 days it is granted here.
It is granted, but he prepones the date of hearing.
Correct,
Kindly
inquiry.
look at the second step of inquiry which contemplates on 28.
After considering
Considering the cost, that is after considering our objection, if any shown by the owner of the land and by any person interested therein, and this is the second step. After giving such owner and person an opportunity of being heard, the state government may pass such orders as it deems. First is you call for objections, take the objections into consideration, and then hold an inquiry. That is a oral inquiry. That is lordships are aware. It is now well settled. Interpreting section 5 of the Land Acquisition Act, Central Act, person deprived of a property, fundamental, if not a fundamental right, a constitutional right. Therefore, opportunity of hearing is necessary. So 28.2, 28.3 contemplates first objection. What the SLO does in this case is, he issues notice under 28.2 for 30 days. Within 30 days, fixes a date of hearing, hears it, and then passes on. Clear transgression of 28.2 and 3. Also, the second argument on procedural fairness is, kindly look at the way he has considered the objections. It's a cyclo-style format he looks into. He considers all the objections of the landowners in 2 pages and says all objections rejected.
Page.
But that is not available because in their statement
Not
of
available
objection,
with us.
our state objections.
Board objection, na?
Yes.
Annexure R9.
Page, it commences from page
R9. 9/10/2024.
Yes. 9/10/20.
9/10.
28.
Objection stated 9/10.
Allala.
Hearing is dated. Yes, R9.
Order is 9/10.
Correct.
28.3.
But if lordships are to see,
Where is the hearing?
the annexure appended to this objection statement, first at page 23 onwards.
23. Illa 22 idu
22,
order.
20.
28.3 order.
Correct.
Cyclo-style order andre?
Page 23 onwards. May I request lordships to, for instance, see our objections, how he has considered it. Page
Yes.
127.
Page.
127. For example, 73, Purvankara or Paravagi, Chairman Sri Nani so and so. Our objection is,
127. Yes.
otherly for column number 73.
I am there.
Yes, sir, so and so Paravagi Vasu Chairman Sri Nani Avaru. What is the objection we have filed? We have said Karnataka State Regulatory Authority ತರ approve ಆಗಿದೆ. Satellite township ring road ಆಗಿದೆ. There is a central government, state government circular. He says ಪ್ರಸ್ತುತ ಜಮೀನನ್ನು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಲು ಈಗಾಗಲೇ ಪ್ರಾರಂಭಿಕ ಅಧಿಸೂಚನೆ ಪ್ರಕಟಿಸಲಾಗಿದ್ದು, ಈ ಜಮೀನು ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಅಗತ್ಯವಿರುತ್ತದೆ. ಭೂ ಮಾಲೀಕರಿಗೆ 2013 ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆಯಂತೆ ಸೂಕ್ತ ಭೂ ಪರಿವಾರ ನೀಡುವುದರಿಂದ ಹಾಗೂ ಇವರ ಆಕ್ಷೇಪಣೆಗಳು ಸಮಂಜಸವಾಗಿಲ್ಲ ಒಂದರಿಂದ ಆಕ್ಷೇಪಣೆಗಳನ್ನು ವಜಾಗೊಳಿಸಿ. ಇದೇ ತರ kindly see for instance note at page 128.
Same.
Yes, and for instance page 7 column number 75 Kalpak Realty ಅವ್ರಿಗೂ ಅದೇ endorsement. 76 same for all of them, lords.
So cyclo-style there.
Cyclo-style answer is given. Now lord, this runs directly contrary to that Calcutta municipality's judgment.
One by one will go.
Yes.
ಈಗ ಈ ground ಮೇಲೆ judgment
Yes, on this
This
ground.
is the first ground.
This is the ground and
then
only
the
4 lines I'll read.
ಅದು ಕೊಡಿ ತೊಂದ್ರೆ. ಕೊಟ್ಟಿದ್ದೀರಾ? So you finish one ground,
Yes, yes,
rely
ma'am.
on that judgment and
Yes.
then go to the next
Yes.
ground.
This Calcutta judgment, lords,
Paragraph
paragraph, lords.
30.2, 3 and 4.
30.2. 30.
Yes.
I'll read that.
Yes.
This
Yes. Yes.
Synopsis itself, not that it becomes
Yes.
easy for lords. Following the right to, they in fact not enumerated number of tests, Lords of Justice Narasimha. Following the right to be a meaningful and effective prior notice of acquisition, the right of the property bearer to communicate his objections and concern to the authority acquiring the property. The right to be heard against the proposed acquisition must be a meaningful and not a sham. Next 30.3. That the authorities have heard and considered the objections is evidenced only through a reasoned order. It is incumbent upon the authority to take an informed decision and communicate the same to the objector. 30.4. That the acquisition must be for a public purpose inherent and important factor on the discretion of the authorities to acquire. This requirement, which conditions the purpose of it, must stand to reason with the larger constitutional goals of welfare state and distributive justice. Therefore, it is a well settled position, but they really not, they also considered they may not be a part
This I have
of.
seen, not a worry.
Yes.
Yes.
Now, therefore, not on this ground, the entire acquisition may have to be
On this
partial.
ground alone.
On this first ground.
Yes.
But what is important is Lordships may kindly now take the next ground.
Next ground.
Now, as I was mentioning before, your Lordships.
So
this is
first
a
ground is
procedure.
cyclostyloid, procedural aberration.
In my summary of submissions, but I have set out all these.
Yeah, ಎಲ್ಲಿದೆ?
Last previous bench argument ಮಾಡುವಾಗ ಕೊಟ್ಟಿದ್ವಿ.
Summary of submission. ಆಯ್ತು ಹೇಳಿ sir.
Yes. ಅಲ್ಲ ಅದಲ್ಲ ಮೇಡಮ್.
We'll get hold of it. Summary of submission.
Summary of written submissions.
List of authorities ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
You have extra. Not right.
Written submissions.
Yes.
No, ಇದು ಯಾವ್ದು AG ಅವ್ರದ್ದು ಇದು. It's here, sir.
Probably here.
Both are here.
The first ground Lordships, if internal page Lords of the written submission,
Yes.
Grounds of challenge ಅಂತ ಇದೆ. First is procedural fairness, internal page 4.
Second is,
Second,
first is grounds of challenge, procedural fairness. Yes, sir.
Second ground, Lords, is acquisition proceedings are bad on account of contravention with directions issued under the circular. Now, state government has issued two circulars. One is 3/3/2013 and 3/3/2017. In essence, it says do not acquire properties which are residential in nature. Apart from other exceptions like temple, mosque, schools, do not acquire. It also says residential in nature. Now, that circular came to be interpreted by the division bench, and they held that lands which were converted for non-agricultural purposes, for residential purposes, if acquired by KIDB, would found, in fact, at internal page 6 ಅಲ್ಲಿ ತಾವು ನನ್ನ written submission ಅಲ್ಲಿ.
Writ appeal 39 of 24.
Yes, writ appeal number 39.
Order.
Order ಇದೆ. In the list of authorities, ಅಲ್ಲಿ first judgment is only that. ಅಲ್ಲಿ ಇದೆ list of authorities.
Allowed, I'll pass it on.
ಬೇಡ, compilation ಅಲ್ಲಿ ಇದ್ರೆ easy.
Compilation ಇಲ್ಲ ಅದು.
ಇಲ್ಲ, ಇನ್ನೊಂದು compilation.
But in that,
Sorry, it's here. Yes.
but in that, if Lordships see the division bench judgment, Lordships get that division bench judgment. Kindly see internal para 3.1, internal page 6 ತಾವು ನೋಡಿದ್ರೆ facts, grounds almost similar to this. Internal page 6, the petitioners stated ಅಂತ ಬನ್ನಿ Lordships ಗೆ. Petitioner stated that they also obtained the conversion certificate for change of land from agriculture use to residential use. The zone change certificate was also obtained.
Sorry, 1 minute.
I'm sorry.
Which division bench? Banur Mat sahib.
39 of 2024.
This is Banur Mat ಅವ್ರದ್ದು.
ಇಲ್ಲ.
ಅಲ್ಲ. 24.
Yes, page 40 in the should have.
ಅಲ್ಲೇ ಹೇಳಿ. Yes. Para 6.
The para 3.1.
Circular dated
So
3/3/2007.
Lordships may kindly see para 3.1.
Yes, sir.
Facts I just wanted to point.
Yes.
Internal page 6. The petitioners stated that they have also obtained conversion certificate for change of land from agricultural use to residential use. The zone change certificate was also obtained. It was stated that the competent planning authority, Bangalore, had also allowed change of designation of the land. It was further the case that the conversion from agriculture to non-agriculture as required under the Karnataka was also certified. The maps were approved. Now, let's kindly see the observation of the division bench at 5.1 first. The Department of Commerce and Industries, Government of Karnataka, therefore, by issuing the said circular dated so and so, laid down the procedure to be undergone before preparing the preliminary notification for acquiring the land for industrial purpose. It provided that the survey should be conducted. It contemplated the temple, memorial, school, playground, dwelling houses, etc. should not be included in the preliminary notification.
5.
Also, the industrial units should be
5.2.
Yes.
Last 3 lines.
Similarly, the subsequent so and so.
Yes,
this note, and then 5.3 also.
5.5.
5.5 minutes.
Mm.
I'm sorry, 5.5 and 5.6. When the aforesaid circulars dated so and so provided not to subject the lands for which conversion was permitted for acquisition under the act and not to include the preliminary notification, the respondent authorities in including the petitioner's land for acquisition conducted themselves contrary to the provisions of the said circular. Sri Venkateshappa court held that the said circular contained a command for the authorities not to subject the lands categorized therein and the classified lands to be excluded from the acquisition. In the said case, the lands were converted for non-agriculture purpose and garden land, and yet they were brought under the acquisition.
All right.
Therefore, my lord, this bench, of course, my lord, this matter was taken up by them before the Honorable Supreme Court. It was confirmed at page 53. SLP was dismissed in Timing.
Yes, sir.
Now, my lord, there is no doubt that insofar as we are concerned, but we not only our lands have been converted for non-agricultural purposes,
Mm.
we also had the benefit of our plan being approved by the STRR, which is not the satellite.
When was it?
Yes, ma'am, I'm giving all the dates. It doesn't matter.
Prior to acquisition?
But conversion of land ranges from 332, several conversion orders have been passed because there were parcels of land. But permit me to state this, ma'am. 3/3/2018 to 4/1/2024. For instance, if I have to point out, just to, there are a number of, I do not want to take, I do not want to be troubled by taking all the orders. For instance, Annexure G16 series.
In the,
Annexure G series in our writ petition. 420.
starts from
Annexure G series.
No.
57.
G page 52.
52.
G series commences at page 50, 4/1/2024.
How?
That is the
Beginning.
conversion.
Conversion orders. Starts a number of conversion orders have been passed. I don't think what the respondent state or KIDB has disputed that. That's assertion by us. Second is not plan approval, which of course happened
Page.
on the day our preliminary notification was issued, but it was a mere coincidence that lots of
After.
application was filed much earlier.
22/11/2000.
Show me the STR. Kindly see page 456.
Plan is also approved immediately.
Yes. Application is filed on, Lordship may kindly note the date, 22/11/2023, page 456.
22/11/23
Page 456.
application.
Application for plan
So
approval.
immediately after conversion, when was the approval come? When did the approval
Came,
come?
they took their time and the approval came on STR.
16th March 2024.
15/3/2024. All right. Sir. Yes.
This preliminary notification was dated 15/3.